Very good morning and welcome. Now, the rule of law is said to be central to the functioning of a democracy. In this country, as we grapple with the implementation of a new constitution, there are many challenges emerging about the government's adherence to the rule of law in many of the activities that it has undertaken to either establish security or make appointments to different public offices. This morning, we want to look at just how far are we complying with the rule of law. And in the studio to help us dissect this issue is an institution that is at the core, at the center of legal services in this country, the Law Society of Kenya. Chairman Eric Mutua, karibu.
Thank you.
Yes, we want to look at the health of the nation from a legal perspective. You're the doctor.
That's right. Yes.
You have been recently engaged in a lot of things. The Law Society has gone to court. There are many challenges out here. There are calls for referendum, amendment to the Constitution, and all these things are happening. How are we doing as a country and the rule of law?
Well, generally speaking, I think, thank you very much. Generally speaking, I think we are not doing very well in terms of adhering to the rule of law because we have seen challenges in terms of violations of constitutional provisions. We have seen challenges in terms of the judiciary. We have seen challenges in terms of the legislature. So all around I can say that generally we are not doing very well in that front of adhering to the rule of law. Yes.
There is an institution called the Commission for the Implementation of the Constitution.
Yes.
Are you taking their role? Because that's not your business. It's them to ensure that it's done.
Well, under the Constitution, they have that mandate of ensuring that the Constitution is fully implemented. However, I think for certain reasons they are limited. And remember, the Law Society also has a mandate which is not really constitutional but through a statute before the Constitution came into place, the current Constitution. And part of the mandate is basically upholding the rule of law, advising the government, advising the public, protecting the public interest. And we undertake our mandate, our role, pursuant to that statute. But overall, any Kenyan, including the Law Society of Kenya, is mandated by the Constitution to take action to protect that Constitution. Going back to that institution, I do not think that it has also performed very well.
You don't think so?
No, I don't think so. We've looked at pronouncements, like the latest pronouncements about the fact that the president has a mandate to vet candidates or persons who have been forwarded to him by the Judicial Service Commission for purposes of being appointed as a judge. The position they took, which I read in the newspaper, was that the president can vet those persons, which is wrong in our view. So I don't think that is effective.
That's why you went to court. So in court, basically, without prejudicing the proceedings there, what is the matter at hand?
We are seeking, first and foremost, let me correct that since under the Constitution you can't sue a sitting president, we have not sued the president. We have sued the Office of Attorney General, and we have sued the Judicial Service Commission. And we are seeking certain declarations.
Right.
And one of the declarations that we are seeking is that, one, under Article 259, Sub-Article 8, the president is constitutionally bound not to take too long in appointing persons who have been nominated by the Judicial Service Commission for purposes of appointment as judges. Right. Because the operative word is that if there is no time frame which has been set by the Constitution or by any other law, then the person who is supposed to act should not act within an unreasonable time.
Right.
And we are trying to get a declaration that the 6 months plus, which the president has taken in appointing these persons, is an unreasonable time. That is one of the declarations. The other declaration we are seeking is that the president has no role of interrogating the candidates for purposes of picking the ones he thinks are suitable and dropping the ones he does not think that they are suitable. That is not his role, and that is what we are seeking the court to make a declaration on.
It is that this seems to be the longest time that the president, has taken to appoint nominees for appointment for judges, right?
Yes, this is the
6
longest.
months?
Yes.
Yes.
6 months plus, yes.
What about when Martha Karua was the Minister for Constitutional Affairs?
No, it didn't.
There are some people who were
There
appointed.
are 3 judges who appointed, including...
There was around there.
Yes, but it took about 3 months.
Took about 3 months.
Yes, yes.
Yeah. But this is also... would I be right to say that we have had problems in terms of how President Uhuru Kenyatta has handled appointments to certain positions? One, I remember there was a prolonged delay in the appointment of the commissioners of National Commission on Human Rights.
Yes.
And now this one of judges seem to follow. What do you detect to be the problem? Is it advice or a reluctance, a political will on his end?
Well, I think let's start with the one for Kenya National Human Rights Commission.
Yes.
I chaired the panel which selected those persons. And after we forwarded the names, initially it was the former president, Mwai Kibaki. When we forwarded those names, there was a delay in appointment of the names which we had selected. Then the president, of course, his term came to an end, and then now the current president, Uhuru Kenyatta, came into office. And what happened is that we got communication from the Office of Attorney General to the effect that we should constitute our panel afresh for purposes of recruiting again. And we refused. We said no, according to the Constitution and according to the Act. Once the names have been forwarded to the president for purposes of appointment, his role is basically to forward those names to Parliament, to the National Assembly. And after we indicated that, we never got any response because we refused to constitute a panel afresh. And then you remember, someone went to court to compel the president to forward the names to Parliament. And
yes.
a decision was made by the court, Justice Lenaola, to the effect that the president has no role other than to forward the names to Parliament. That is when now the names were forwarded to Parliament, and that is when the appointment occurred. And it took 2 years for those commissioners to be appointed.
Yes, they got into office 3 months ago. Is it? Yeah.
Yes. So to go back to your question,
yeah.
I think there are people within the presidency who probably think that they can violate the Constitution, they can violate the law, and people will basically keep quiet, and eventually people will get tired and they'll have their way. Basically, that is the explanation you can have.
What do you think, or you want to take it this, that Attorney General
Yes.
did advise you to reconstitute yourself?
Yes.
Knowing very well that it cannot be done.
Yes.
He's a senior counsel.
Yes.
And he did advise of that. So what do you think of that?
Well, in my view, either it is incompetence or probably it is a question of trying to be politically correct by not advising your client, who is the president, the right manner, and advising him in a manner in which you think he would want to perform his duties. That is the only explanation, because if you look at the law, it was very clear. It is clear now that the president can do nothing other than forwarding the names. Yet, we got a letter being told that we need to reconstitute.
But if you have serious grouses with the Office of the Attorney General, what do you expect once the security of tenure was removed? He must be politically correct. He's not like the DPP who is there, security. He does not have security.
You see,
what do you expect?
No, I don't think the question is security of tenure. Then we do not need the Office of Attorney General. If at all we are going to have the Attorney General who will perform his duties according to the will of the executive, then we don't need the Attorney General. We have legal advisors within the presidency who can perform that duty. The role of the Attorney General is first to protect the public interest. That is constitutional provision, that he must protect the public interest. He must advise the government. And as a
public interest includes the government.
Well, public interest is larger than the government. And if you are advising and giving an opinion contrary to what is good for the public, what is good in terms of the Constitution, then you're not performing your duty. So in my view, you don't have to have security of tenure for you to perform your duty. I mean, how many people have security of tenure?
You also have a professional obligation, right?
Of course, the calling itself, as an advocate, as a lawyer, it behoves that hold of that office to act in a professional manner.
Yes. So you do think that, for example, in the course of the delayed appointment, not just delay, perhaps even the decision to appoint only a few, is attributable to bad legal advice, not the president's own desire not to appoint these people?
Let me say this.
If it is safe for you to venture an opinion there.
What I could say is this. Yeah. The Constitution is so clear about what happens to the appointment of judges that I do not think that the decision not to appoint the 14 was based on misinterpretation of the law. I don't think so. I think it was deliberate. And this is why I'm saying this. Remember, the appointment of judges extends to the appointment of the Chief Justice, the Deputy Chief Justice. The office of the Chief Justice will be vacant in another 2.5 years or so. The office of the Deputy Chief Justice is going to be vacant in almost the same period of time. There are about half of the Supreme Court judges will not be sitting in the next during the next elections, national elections, and the appointments will have to be done. So, if it will be in the interest of the executive to get itself some role in the appointment by starting with the small position of judges, and if they can be able to put that in the mind of Kenyans that indeed we have a role to play, and they succeed in convincing and also carrying out that role, they succeed in convincing Kenyans and carrying out that role, then when it comes to the appointment of the Chief Justice, remember 3 names will be forwarded probably, or the appointment of Supreme Court judges, some names will be forwarded. I would say, look, I established a president, I vetted the 25, I picked 11, and that president was established, nobody said anything. So in this particular case, I'm going to pick so-and-so to sit out of the names which have been forwarded for the interest of controlling the judiciary. So it is a big issue in my view. So that is why we decided that we don't just leave it because these are judges and they are 14.
You need a declaration.
We need a declaration for the court to make a determination.
The president has no role except the ceremonial appointment.
And that is the only way you can protect constitutional gains in a constitutional manner through courts of law. That is what we've adopted.
Let us assume, okay, let's look at the process of vetting that you went through, that they went through in this particular, not the commission of the GSC. Supposing, okay, the formal vetting is done by the GSC, but there's a security vetting which is done outside the GSC because there's no recommendation of NIS on the Judicial Service Commission.
No, let me tell you this, not cutting you short, but I've sat in interviews. I've said that I've chaired the Kenya National Human Rights Commission panel. We always get reports from all agencies, not the NSIS, the Anti-Corruption Commission, the police. You get these reports, confidential reports about a candidate. And I'm certain, even under the law, the Judicial Service Commission gets all these reports. And if they have gotten these reports as regards those candidates, and the reports are not negative, they are positive, then I do not understand how another report would come out outside there
so
to say that so-and-so is not suitable.
Imagination what kind of additional vetting the president would be, or examination or evaluation would be putting the names to. Okay, anyway, let's move on from there. So there are issues around rule of law, there are compliance with the procedure. There is a lot of brouhaha around other forms of violations of the law across the country. There has been a pressure from the government with regard to the terror operations, terrorism security. And the government has said, look, the judiciary is being too generous, releasing people on bail who are going out there to disappearing into the woods and perpetrating more terror. What is the perspective of the Law Society of Kenya on this tango between the executive and the judiciary?
Well, you see, the judiciary operates within the law. That is one. If the Constitution provides that all offenses are bailable, there is no reason that a magistrate or a judge would refuse to bail, to grant bail to a candidate, unless there are compelling reasons. You must specifically look at a particular case and say, because of this and this and this, we do not think that this suspect ought to be released on bail. And we have offered a solution. We've said that the only way to deal with this question, because there are competing interests here, there are interests of the suspect or the accused person who is entitled to bail. There are interests of the public, where the police and the executive are saying that these people, you release them on bail, they'll go and commit the same offense. You release them on bail, they will be free to do what they do. So what you do is, and it has been done elsewhere, you constitute that court within 2 weeks, hear that matter consecutively for a week, and deliver a decision. That is the only way to deal with these cases, and there are not many. These are cases where if investigations have been done,
them.
yeah, you prioritize, and that has happened. I remember that some Americans who were in the country, and they were robbed in the streets of Nairobi, and the Chief Justice then gave a policy direction and said, because these are tourists who are going back, hear this case within a week. And the case was heard within a week. The second week, a decision was rendered. Those accused persons were convicted, and they served jail, and the Americans went back. Why can't it be done on the question of terrorism?
Let's go back to another subject about the same, what is happening in Parliament.
Yes.
There is a move to make amendments, which seems like they are taking us back to where it used to be. For instance, the powers of the National Intelligence Service.
Yes.
They want to enhance power for him to appoint his deputies.
Yes.
They want also to do things to do with the Inspector General of Police, give him more powers.
That was already done, in fact.
It's already done.
And
the president also signed it, yes.
And what do you think about that?
No, somebody will go to court and it will be declared unconstitutional. There are aspects of that act which are unconstitutional.
Of the police, the amendments, the Police Act,
yes, Police Service Act, yes.
But nobody has.
I'm certain, let me tell you, I'm certain. And if the only problem we have not discussed this, but the only problem we have and only conflict of interest is that in that amendment, the Law Society of Kenya has been made a party to the panel.
That appoints
yes.
the Inspector General.
Yes, and we are yet to discuss and see how we could probably take it up. But I'm sure we have already identified that the fact that there are certain amendments which are unconstitutional.
The appointment of the Inspector General had no role for the President, except, again, submitting the names.
Yes.
But what the amendments have moved that power from the Commission.
Now the President will be able to pick the team which would constitute itself as a panel for purposes of the interviews of the Commissioner. What that therefore means is that if the President has control over the institutions, the membership, then it is very easy.
Which means it will not be done by the
National Police Service Commission has lost that power.
But you see, the Constitution says otherwise.
What is it for?
The Constitution says exactly the Commission is the one that appoints. But let me ask you, when these bills and laws come before the House, don't they pass through the Attorney General and the Law Reform Commission?
No, not the CIC.
The CIC is only with the constitutional bills. But these are general legislation. Amendments, don't they pass through the Law Reform Commission and the Attorney General before they come to, and the relevant ministry, which has got legal advisors, before they come to the floor?
You see, the problem we have is that, as I said, the Honorable Attorney General could very well be aware that there are constitutional issues in this bill. But since the line ministries would probably have generated that bill and insisted that from the cabinet point of view, this is what ought to go to Parliament.
Right.
It becomes very difficult for him unless he stands his ground and puts it in paper and pen and does an opinion to say that this is unconstitutional. It becomes very difficult for him to stand between the bill in Parliament in terms of his advice and what probably majority of parliamentarians want, or what the executive wants.
But the Parliament is full of lawyers.
Yes.
Where these things
But they're
happen.
also politicians, with political affiliation,
But
colored
if
opinions.
something is unconstitutional, it's unconstitutional.
Let me tell you the beauty about all this. I don't even I regret to some extent that there are those kind of laws which are coming out from Parliament. But the solace for us is that we have a court or a judiciary which can be able to rectify that. The moment you pass legislation which is unconstitutional, I know for certain that courts will look at it and they will declare some of the sections in the act as unconstitutional. I mean, for me, the judiciary, to a great extent, has be able to deal with that.
Yeah.
Yes.
But, okay, the other thing is that the Constitution requires legislation and all public affairs to be participatory, popular participation.
Yes.
The bills we are talking about, and a lot of amendments which are coming to the House, including some which were being rejected by the President, sent back to the House.
Yes.
What do you think? I mean, are you satisfied with the level of public participation in legislative matters, for example, in Parliament? The whole thing that power to legislate is donated to Parliament and the sovereign will of the people expressed in the House. I mean, this argument has been pushed quite. Are we experiencing the fruits of that democracy?
Well, not fully. I know there are about 3 or 4 cases which have gone to court for the court to make declarations that when this piece of legislation was passed, there was no public participation. And the courts have borrowed the South African experience and questioned the select committee of Parliament responsible for that to find out what exactly that they did. And the courts have been able to get satisfied to some extent that what the select committees have done in terms of calling for engagement with stakeholders is so far adequate, because the parameters have not been drawn yet. So you cannot say that there is full participation, but there is an extent to which Parliament consults.
Yes.
For instance, on our part as the Law Society, any bill, we make it our mandate to comment even before we are invited by Parliament. We always comment on it, and we send our memoranda to say this is what we expect of the bill. This is what we think ought to be done. But that probably is just for the Law Society. Unless you have that initiative as an institution, as an individual,
to be interested in the legislation coming before the House.
Yes.
But so what are the avenues for public participation, in fact? Because the requirement is that all legislation, draft bills, be published in the Kenya Gazette.
Yes, yes.
Of what circulation is that? Isn't this something that the public, I mean, and the Law Society perhaps ought to take up in terms of spreading the avenues for public participation in legislation? So, because the Kenya Gazette circulates, I mean, how many Kenyans read the Kenya Gazette? Should we use the national newspapers to publish bills so the public participates in the legislation?
Well, there have been attempts, to be fair, there have been attempts when some legislation, new legislation,
have been published
in the newspapers. And also, I think there are instances which I can recollect where majority of the bills, we get invitations to attend workshop to discuss the bills, the draft legislation. There is an extent to which, unless I'm just talking from the point of view of the Law Society, because we've got
because you're at the center of this.
Yes, we get a lot of invitations, and we have committees which deal with various aspects of the law. And when we get one, we would second that committee to go and sit in that workshop and deliberate. But I think probably that is why I'm saying maybe I'm talking from that point of view. Maybe majority of Kenyans do not have the advantage of looking at those bills.
Let's look at your other matter which you have taken to court. You took Olelenku.
We gave...
The security seems to have been a big problem in the country. Looks like government is grappling with it. You took that extraordinary measure of seeking the dismissal of a cabinet secretary. We
got encouraged by the... First, let me say that we have not filed suit yet, but we issued a demand note, and our lawyers, Dego and Company, they are working on the paperwork, and probably in the next 1 week or so, we should expect the papers to be filed. But we got encouraged by the fact that when we took the traffic commandant to court to seek declarations that he is not suitable to hold office in view of the fact that there has been a lot of accidents on our roads. He filed a response which was self-incriminating, and that is what was used to get him transferred. And for us, as a public interest litigation, it is a question of trying to achieve some remedy, which is not forthcoming. That is why we decided that we are going to file suit against both the Cabinet Secretary, Mr. Olelenku, and the Commissioner of the Inspector General of Police,
right,
to indicate the failures to protect the public, failures to protect life, failures to protect property, and there are constitutional provisions which require and dictate that they must be able to demonstrate what they have done. And if they cannot demonstrate what they have done, then a court of law can be able to independently look at what claim has been brought forward and make a declaration.
right.
Yeah, once we get a declaration, it is a question of asking the executive to deal with the declaration. It's a question of asking Parliament to deal with the declaration.
Right.
Yes.
In the instance of insecurity, you think that there has not been sufficient accountability on the part of the IG and the CS?
I don't think there's been accountability, and I don't think the proper moves or action is being done to contain insecurity, in my view, especially the question of Lamu. I know insecurity is a complicated docket. I'm not an expert in security. But as a layman, I have a right to question and ask if we have an attack in a particular area and we send our security forces down in that area, I don't expect the following night to be an attack. As a layman, I'm just talking as a layman, I'll need to be explained and told the reason why this has happened is because we did this, but then they did this. That is the explanation we are seeking, and one is entitled to seek that explanation. Otherwise, we'll just sit tight, saying that these are security issues, and Kenyans will keep on dying.
There is somebody who has explained, people say that the reason why this is happening is because of the new constitution and the new setup of things, that people are so independent of each other. There is no joint command.
No, I think that is an escapist way of thinking. There's nothing.
They don't share information.
No. I don't think so. Look at the Constitution. The IG is on top there. You can't say that the Inspector General of Police has no command over his forces.
Get information from. Can he demand information from the intelligence?
He can demand information, and if he doesn't get that information, he has a responsibility to say, I'm failing because the intelligence has failed to provide me with security. Then Kenyans will deal with the intelligence arm. That is basically what needs to happen.
Right.
Yes.
You
remember, let me, before that,
yes.
You remember Westgate?
Yes.
I was very impressed when in Parliament, the Director of Intelligence came and said, look, I played my role, I played my part, and I gave this information, and I gave it to the police. For him, nobody questioned after that.
Yes.
Because he cleared himself and said, look, I gave this information. What they do with that information is not my role. That is the kind of information we want coming out.
You can interrogate
in the new amendment that is coming.
Yes.
The intelligent people, they want to go and arrest people without having to seek warrant.
No, they can't. They should. That is unconstitutional. They wouldn't be allowed to do that.
Really?
Yes,
Why not?
They can't.
They are policemen.
Yeah, they are policemen, but you can't just walk into somebody and say, I suspect that you, and I arrest you.
Yeah, there is a warrant process.
Yes.
If you are suspected of criminality,
you must investigate, come up with some cogent evidence on something.
Yes.
But if you leave it open like that, it is prone to abuse.
Yeah. Let's look at the contentious matter that, people have said this is personal between you and the Attorney General. You want to punish him, you want to dishonor him, you want to humiliate him. Some people looking at it say, this guy is on a mission to fix the Attorney General.
No.
What is the big issue here?
There's nothing personal between me and the
He has responded
General.
with
If he was my teacher.
Yes.
He was my teacher.
Yes, he was my teacher. He's a professor of law. He's a respected lawyer by all standards. But when we looked at the question of Anglo Leasing as a whole, it's quite huge. It's a mega scandal. but we narrowed down and looked at the latest payments. And we went and looked at what is the rationale for this payment. This payment was sanctioned by a court of law. How was the process undertaken in court? And that is what we've narrowed down our issue. And we said we have...
Court of law, not in Nairobi.
Not in Nairobi, in London. The London one and Switzerland. And we narrowed down and we said, look, these are the proceedings. And we looked at the proceedings. We know the procedure in London. We know the procedure in court. And we said, according to us, there is a question mark in this whole process.
Yes.
And we asked, could we have answers on this? And all we are saying, without going to the merits of the court case, we are saying we give you a role of honor. When we think that you're exemplary in your work, in your profession, we give you what we award you a role of honor, where we honor you as a society. And it is our mandate, if we think that you've not been up to the standards which we thought you were up to, it is our mandate to say we can dishonor you. And basically we are basing that on, and we've not done it, and we said we need an explanation. We never got an explanation. What we got was an injunction. Yes. We were told that you cannot...
sought him to show cause why he should not be
we said we have looked at the proceedings, and these proceedings do not match to the standard which is expected. We have given reasons. We have looked at the lawyer in England who was appointed by the Kenyan government to act. And we have looked at the letters is written disparately saying you need to defend this application. You have not replied to this application. The consequences are grave. You don't file, you don't respond. We have looked at the question, the law is still on record. We have seen the Attorney General sends the Solicitor General to London Court and prepared without knowing the facts of the case. And you can discern that from the proceedings. And we said, look, we don't want to judge you, Ashley. Please explain to us all this. When we call you to explain that, you now go to court and get an injunction against the society discussing that issue. That is basically what has happened. We will respect that decision, but it's a wrong decision.
Right.
Yeah.
Okay. So nothing personal.
There's nothing, I mean, there's nothing personal, absolute. We just looked at, instead of dealing, I mean, because we may not deal with this Anglo Leasing issue, as a society, because it has many facets. But we can narrow down and say, look, the President of the Republic of Kenya, His Excellency Honorable Uhuru Kenyatta, says, I've been constrained to pay because I have a decision from court which says you must pay, and I've got an opinion from my lawyers that there is no right of appeal. When the right of appeal is there. Yeah. Those are the things we have looked at.
The society went to court on the same matter of Anglo Leasing, but it was too late. Or what happened?
We went to court.
Was dismissed.
No, it was not dismissed. We went to court over the same issue to stop the payments. Unfortunately, the first instance, we didn't get an injunction, an order stopping the payment, because apparently the judge in his decision says that, Justice Majanja says that there is no imminent danger of this payment being made. Yes. A week after his ruling, the payment is made. So it is overtaken by events, but we've taken it up to the Court of Appeal because we did not seek just to stop the 1.4. We were seeking to stop other payments. Yes.
Let's look at hate speech. It's been in the air. You guys took, the Law Society of Kenya took or asked the DPP to prosecute some individuals for hate speech.
Yes.
What motivated you to come out? And then secondly, there has been a lot of hate speech alleged against politicians in court having rallies. People have been saying there's hate speech. Some have been questioned by the police with a view to charging them. You have not seen any hate speech in those rallies?
No, you see, we saw it coming.
Yes.
We knew that the tensions are going to rise because of the threats by CORD to have these rallies. We knew that, and we were looking at what was in Facebook. We have an IT department which advises us on all this. And we thought that since nobody seems to be acting, it appears the polarization, it appears the tensions will keep on rising because nobody seems to be cautioning politicians and people on Facebook that you're trending on dangerous grounds. And we said, let's start by saying, look, somebody posted what we thought in ourselves is hate speech. There's no doubt about it. And we said, look, Mr. DPP, we think this needs to be investigated. And I tell people that if it were not for the fact that we are the first persons as Law Society who came up and said, look, this needs to be arrested, there would be no investigations, there would be no arrests which have been made. But we raised those issues, and people now began to understand that we need to arrest this situation. And that is why we have seen all this happening. And I can tell you, whether people like it or not, it is as a result of the action which is being taken now that we have seen instances of hate speech subsiding. That is why, I mean, for the last 3 weeks or so, or let's say 1 month, the kind of pronouncements from politicians has come down.
Following up, okay.
On the day of the Great Sabasaba,
yes,
media houses decided to cover that event live.
yes.
And there has been divided opinion whether it was justified or not justified. What is your opinion as a lawyer and as a law society? I don't know that you have discussed about.
This is my own opinion. Yes. We have not discussed, but I think there's an extent to which there are people there are people who scheme over time, and they get it right all the time. Probably for me, for politics. I remember during the just concluded general elections, there was a scheme where the media was told that you should not cover certain aspects, and probably that played very well for some political party or some political wing. And I think someone again decided that for some reason, if you cover this event live, you would give advantage to code or something like that. I don't think covering it live would have necessarily translated into violence from code. I don't think so.
The rationale is that we're going to give vent to potential hate speech being mouthed directly to the public. That is the caution that the media seem to have taken.
Yes, but you can always...
Was that a rational decision?
I don't think it was, because we know there is a law against hate speech. And if one does that... They're
culpable
yes,
at an individual level.
As an individual level, there is law to that extent. You break the law, you'll be arrested.
Being incorporated in the suit?
No, the kind of... In fact, if you look at the Act, it only talks about it being a misconduct of some sort. There can be disciplinary processes, but there is no criminal culpability on the media house. So for me, the caution, I mean, the media houses were being too cautious. Okay. In my view.
Well, we're just about to finish, but now, of course, there is the momentum push for referendum,
yes,
amendments to the Constitution, even amendments through the Parliament, which are being mooted,
yes,
by MPs. Others argue that we ought to leave the Constitution to remain sacrosanct. If we try to amend it now, we'll open a floodgate. Do you think, as Law Society, we have had a discussion about it, there is merit for any amendments to the Constitution or the changes being sought? And is there feasibility for this referenda being agitated for?
For me, the view I take, and I think this is shared by the Council of the Law Society, that we should not tamper with the Constitution. That is the view we hold. There are certain aspects of the Constitution which may require some amendment, but they are not so fundamental that we cannot operate as a country. They are not so fundamental that we cannot move forward as a country. The danger of opening up amendments to the Constitution are that what the political class may not want, both sides, whether you're in CORD or you're in Jubilee, what they may not want for their political expediency may be taken to the public or to Parliament for purposes of an amendment, for purposes of suiting a specific interest. That is the danger of opening up the question of amendment to the Constitution. So it is it is a situation which needs a lot of discussion. I don't think it's right for people to just jump into the conclusion that we need to amend the Constitution. Right. Because given the history of the amendments we've undertaken, yes, the moment we open up these amendments, we don't know where to stop.
All right.
Yes.
There are a lot of feedback. There's a lot of feedback from people out there, including your friend, the former commandant of traffic, Samuel Kimaru. Kimaru says you should leave him alone, but
no, I just mentioned that. I didn't.
Well, yes, it's me who asked you to put it in context. So
yes,
I think
yes,
Kimaru also, you should understand, we're not discussing the merits of your case. It is the action that LOSAT is taking in the interest of the law, of the rule of law, that we are keen to follow up here. But there is something persistently coming up about Malili.
Yes.
You seem to have a matter to do with Malili. People think you...
Yeah. I knew that yes, someone would ask that.
Yes, in fact, there are several people saying, Makali, don't leave Mutua without asking about Malili.
You see, we acted as a law firm for the sale transaction of Malili, and I don't want to say much because this file now is under investigation, following my complaint, saying that I don't like the way these investigations are being carried because I'm being questioned on issues relating to my professional work. Yes. We acted in a transaction of a sale, and I want to be very simple to the public.
Put the facts here.
The government advertised to buy 5,000 acres of land. My client, whom I act for, had more than 5,000 acres of land. And my client told me, tender for that work. And we tendered for that. I wrote a letter and said, we are offering to sell this kind of land for this much. We were competitive, and we got a letter saying that, yes, you have won the tender. And after winning the tender, we were told, now let's go to an agreement. We put it in an agreement form. We drew the agreement, we took it to the Attorney General, they looked at the agreement, they were satisfied, every party signed the agreement, and payments were made. On account of acting in that kind of a manner, somebody says that I have an issue about Malili. If the government says that it bought the land at a price which was exaggerated, it is something which was open. It's not my fault, it's not my client's fault.
So what is the issue in dispute? What are the what is the controversy?
The controversy from
the allegations.
The allegations are that one, the price was exaggerated. Yeah. That is one. But this is an open with a tender where we tendered with everybody else.
That is for the government to answer.
That is
bought land at a higher price.
Yes. There was also the question of the money going to the members. You know, within the 5,000 acres, there were individual members who had plots there.
Yes.
There are people who are saying the amount of money which was paid to the members was not adequate, or some have not been paid. And my question is, as a lawyer, I deal with board resolutions. If I'm told by my client in a board resolution that this is the much you're supposed to pay, and this is the balance you pay to these people, yeah, it is not my role. I mean, as a lawyer, you can even pay Lucifer. If it's Lucifer, somebody says pay Lucifer, you will pay Lucifer.
You do?
Yes.
You follow the instructions.
I mean, I follow. But if I don't follow instructions for my client,
yeah,
I'll have conducted myself in unprofessional manner. I follow instructions. I don't act without instructions.
Yeah.
But if somebody tried to bring in that issue, in my view, probably to try and slow me down.
Yeah.
What about the involvement of the Kitui, the court?
No, there's no. I mean, I'm a petitioner in a case in Machakos, which we have finished the arguments in Machakos court. We are waiting a decision. I'm the first petitioner to say that we need public participation in executing the documents, in agreeing on the terms and conditions of the mining agreement. That is what, yes, over the coal mining. That is what you're asking, yes, I believe, yes.
But the contract has been given.
Yes, but we protested and indicated one of the prayers is that we want to have this contract nullified because there was no participation, even to the extent by the county, even to some extent by Parliament.
Well, there may not have been participation, but is the contract fair?
Some of the issues we are raising there are questions of the interests of the community in the contract, the contents, yes, of the and to some extent, to be fair to the ministry, they have agreed on certain aspects through an addenda which we have drawn, indicating that these are the issues which were left out, and we need them to be incorporated in the contract. And to some extent, they have agreed on that on principle.
Yeah.
Yes.
More work for you, but I hope this is for the future. Hello, yesterday's police recruitment was marred by bribery. Can the Law Society take it up?
Yeah.
Well,
I've
been away. I've not followed
that
up.
Is coming to your table.
Yes, yes.
But
yes,
let me
yes,
ask you,
yes.
the last one, the Judicial Service Commission, nominees, Professor Ogenda and I think Agri Michelle,
yes,
Justice.
Yes.
Have they been?
Yes, they have been
taken office.
They have taken office. They are sitting. Yes, after some delay.
Again.
But they are now. What we don't have is the president is entitled to 2 persons to sit in the Judicial Service Commission.
Yes.
Which one of them is their term has elapsed, Professor
Mango.
Yes, yes. But we don't have a replacement.
Yeah.
That is what is being awaited.
Again, that's taking some time.
Yes.
All right, let's leave it there. Let me thank you for coming to shed light on quite a variety of issues affecting the state of rule of law in the country. Many contentions, Law Society taking up public interest litigation to ensure the law is followed. It's also your right as a citizen to ensure that the law is followed. Thank you for watching.